All rise. Ladies and gentlemen, the Supreme Court of Alabama. Hear ye, hear ye. The Supreme Court of Alabama is now in session. God save the state of Alabama and these United States, and bless this honorable court.
Be seated. Good morning, everybody. Madam Clerk, would you call our first case?
Case number SC 2025-0022, Envoy Air Incorporated v. Jada Creagh, an appeal from the Mobile Circuit Court. Arguing for the appellant, the Honorable Forrest Latta, and arguing for the appellee, the Honorable James Daly.
Mr. Latta, are you ready? Okay, you may begin.
Thank you, Your Honor. May it please the court. This is a workers' comp case originally against Envoy Air, my client, which operated the local commuter aircraft out of the Mobile airport on behalf of American Airlines. They had an employee that they terminated, and she subsequently then filed a workers' compensation claim against Envoy. And during the course of that workers' compensation case, some interrogatories were served on Envoy, and its defense counsel filed some responses that contained an incorrect answer stating that she had voluntarily resigned when actually she had been terminated. Her lawyers then filed an amendment in the workers' comp case to add a claim for retaliatory discharge. And from then on, this case became about whether or not those incorrect answers could be attributed to Envoy as evidence of pretext for their termination of this employee. And so that evidence then came into trial, in a jury trial, where the jury was allowed to hear this incorrect answer that was not properly attested as evidence against Envoy. And that resulted in a jury verdict that we've appealed and that we're here on today. There are three big issues that we want to bring to the court's attention. The first one has to do with the evidentiary basis for that interrogatory answer having come in. I'll say the improper evidentiary basis. The simple answer is it's not evidence. It was not evidence. The interrogatory answer either had a drafting error or an incorrect factual statement by defense counsel. It later was served with a signature that purported to be from someone at Envoy, but was determined by a special master to be a forgery, and it had been notarized, and so it was not imputable to Envoy. It didn't come from Envoy. It wasn't a factual position that Envoy had taken, and because of the fact that it wasn't properly verified, it doesn't even meet the minimum criteria to be admissible under our rules of evidence. And you can name 4 or 5 different rules of evidence that it would violate. There's no rule of evidence that it would allow it to have properly come in. So it was highly prejudicial against. Yes.
Did you preserve your argument on the admissibility of the interrogatory?
Absolutely, Your Honor. Yes. The most important thing to look at is the motion in limine that was filed before the trial began. It was motion in limine number 2. And it's at page 1044 of the record, by the way. That was argued to the court, and then it was renewed throughout the trial. When you see the discussion throughout the trial, especially around pages 290 to 310 of the transcript, you'll see a lot of back and forth with the court struggling about what to do, about how to admit that. But the baseline ruling that allowed it in and denied Envoy's motion to keep it out had been made before trial in a hearing on that motion in limine. That's not in the record, but everything you see in the back and forth with the judge where counsel is trying to protect the record while having preserved that objection at the beginning.
Mr. Latta, let me go ahead.
No, go ahead.
Mr. Latta, the I guess finding by the special master that it was a forged signature, is that just a fact that we are supposed to take as a fact?
Yes, Your Honor, we think so because it was not appealed from. It was adopted by the trial court.
In an order?
Yes, it was adopted in an order, Your Honor. It's page 2151 of the record, 2151, where he adopts the special master's proposed order as to the findings of fact, but not the analysis. This was attorney Michael Upchurch, who spent 2 days hearing the case and then wrote about a 25-page recommendation to provide to the trial judge. And in it, he went through and recounted all of his findings of fact, and then he provided an analysis. And so the trial judge adopted the findings of fact in this order that I just cited to Your Honor.
And the forgery was something that was still within Envoy's control, or is you're trying to say that the plaintiff's lawyers did this? I mean, how did this forgery come about?
It's a very interesting report from the special master that I would recommend to all of you to read. He goes through and recounts how this kind of thing can happen. Defense counsel had in his file the correct information about the termination of the employee, but somehow, through a drafting error, when he was dictating the draft responses to interrogatories, he put in there that she had voluntarily resigned.
I understand that part, but it's the finding that there was a forgery.
Yes.
Okay, so is that still something that's attributable to Envoy?
Your Honor, we don't think so. You all have some cases where you've dealt with similar questions of when a lawyer's conduct can be imputed to the client. Usually that's in situations where there's notice of a hearing, a notice of a trial, or an obligation to produce documents that's not done, but not where a lawyer takes an incorrect factual position, especially on something that can be amended, like an answer. I know I've put incorrect facts in an answer before. We've had to come back and correct it and amend it. Same thing in discovery responses. That should not become a gotcha moment for the other side where they can say, hey, your client now is obligated by the fact that the lawyer made an incorrect statement in that. Now,
Well, but it went beyond an incorrect statement, right? There was a written document with a signature that had been notarized. Was the other side not to rely on that?
No, see, so the client had no involvement in that at all.
I know, but as far as getting that, was the attorneys on the other side not to rely on the fact that there was now a signature on the interrogatories when before they were unsigned?
They certainly had a right to at least initially look at it, rely on it, investigate it, but then when it turned out to be not true, since everyone knew it was not true, it couldn't be properly authenticated and admitted as evidence at trial. Your Honor, if I could make one more point about what you just said. It's one thing to say it's notice to them of that particular fact, and I'm sure they found it interesting. It's another thing, though, to say this can be evidence proven against Envoy. We can hold Envoy responsible for that this is proof of something that Envoy did in its position, and that would not be what that evidence would stand for in that situation. In other words, if you were to offer it for the proof of the matter asserted, then you would say, okay, this is evidence that Envoy really did take the position that she voluntarily resigned, when no one believes that. I think everyone knows that that's incorrect.
But it was Envoy's lawyer that sent those interrogatory answers to the plaintiffs, right?
That's correct.
And the testimony, there was a deposition taken of Envoy's lawyer, right?
Yes.
And he testified in the deposition that he did not forge the signature, right?
He says he did not,
So
but he
doesn't
does
that make
not
it a
deny
jury
that that was
question?
not signed. He agrees that it was not signed by.
Doesn't that make it a jury question? If the trial judge is trial judge is supposed to be under Rule 104 of the evidence rules. He's supposed to decide, is there a threshold this is what it's supposed to be? And he decided that it passed that threshold. And isn't that a jury question about whether it's forged or not?
Well, that would make it a jury question of whether or not it's admissible. What he decided to do was he referred it to the special master to try to get to the bottom of whether that discovery response was authentic or not. And the special master found that it was not authentic.
But the special master is not the fact finder.
No, but the judge adopted those findings of fact that were conducted in that evidentiary hearing. And so that then became a baseline ruling where the judge found as fact that discovery response had been forged and was not authentic and not attributable to Envoy for that purpose.
He ultimately kept the forged signature out of evidence, didn't he?
No, and yes, he changed his mind. If you see it, it's very interesting. You know, great respect for this judge. You can see him struggling back and forth with what to
Agree.
do,
Yeah.
whether to let it come in at all. One of the things he did that we think was error was he didn't allow Envoy to provide the backstory on that because he did not want to implicate a parallel case against the lawyer who was responsible for that discovery response.
So that's I agree with you that if he's going to let it in, then Envoy should be able to tell the rest of the story. Did you make an offer of proof of what it was that you were going to show, that this was forged and your lawyer had done it and he wasn't authorized to do this? And
the the special master's report is the best offer of proof that one could have. And so that was a 2-day evidentiary hearing, like a mini trial, where all of that evidence was put on by Envoy.
Mr. Latter, is there any dispute whether this lady was terminated or whether she resigned? I mean, that seems what this discovery goes towards, and it seems from my review of it that everybody acknowledges the fact that she didn't resign and she was in fact terminated. So is that fact established?
Yes, she was terminated. The plaintiff alleges that she was terminated. It's a prima facie element of their case to prove that she was terminated.
So if that's the fact about this interrogatory and both sides agree, I'm just unclear why the court would even let it in unless it's going towards bad action on behalf of your client, which seems to be somewhat irrelevant to this whole discussion of what her status was. If she resigned, obviously it's a different thing, or if they're using this to say it's wrongful retaliation. That I'm having a hard time understanding how that matches up. But the bigger question to me is, she also engaged in some activities that I see from the record where there was a doctor's report that was incorrectly done. Do those cancel each other out, or how do we stack those up to decide? Are we trying to decide who's naughty and nice in this situation and let the scales of justice balance that out, or is that issue more important than the forged discovery?
I hadn't thought about the symmetry that you point out there, but in a sense, there are some similar issues. The first issue has to do with whether there was a material fact in dispute about whether she was terminated or not. And we say there was not a material fact dispute, and therefore that was another reason why this evidence shouldn't have come in under the basic rule that it must be relevant to some material fact dispute. But beyond that, the other side had argued that it might be admissible as indication of an expression by the defendant that there were other reasons for the termination, that it was a pretext, in other words. And so that was what they were trying to offer. This leads over into the question of the sole causation standard under the wrongful termination law statute. Under the sole causation standard, the plaintiff would have to prove that the reason stated for the termination, which was her falsifying that medical record, was a pretext, and that the real reason was that she had filed a workers' comp claim. But we think the evidence was undisputed that there were more people involved, if not solely involved, in making that decision on the termination. And so under the sole causation standard, the case never should have gone to the jury because of that doctor's report that you talked about.
On your argument on this point, how much does your argument rise or fall on the notion that the HR employee in Dallas was the sole decision maker versus supervisor? Because I took your friend on the other side spent a lot of time sort of explaining that actually maybe the jury could have found that actually the supervisor was the decision maker. And it seems like your argument may be more the latter. And isn't that, if that's the right, aren't we then being asked to reweigh the evidence, which is something that I don't think we can do as a reviewing court?
Very good question. I first want you to, as we've said in our reply brief, look very closely at their record citations where they claim that the evidence was that the supervisor made the decision. She did not. Everything in the record would show that she did not make the decision. She was the messenger. She was the person who delivered it, But the message was made out in Texas by someone in the HR department, and there's plenty of documentation to show that very clearly, and we've even reprinted some of it in our reply brief. But to your question about does it matter? Yes, it does matter to some extent, in the sense that under the sole causation standard, they would have to show that Bridget, the supervisor, was the only person involved in the decision, and that no one else had any input who had good motive or who had no awareness of the idea that somebody was claiming that Bridget had framed the plaintiff. And so here we have a person out in Texas who was the director, the HR director that was involved in that decision, and he was actually the person that made the decision. I say all that to say that under the sole causation standard, if you have a mixture of good reasons and bad reasons and wrong reasons, then the plaintiff is not entitled to win. Okay?
Let me move you to the emotional harm question, because I'm intrigued by your argument that there is no physical injury here, and therefore we have to look at emotional harm damages with more scrutiny, like our case law has said. There was $250,000 of emotional harm damage here awarded. Tell me what you think the number should be if we were to remit that.
Thank you for bringing that up. I hope you don't get to that issue, but that's certainly a very important issue, I think, that the court's going to have to take a look at in this case or another case, and I hope you could see that in the brief. We put a lot of work into this discussion of the mental anguish standards in our brief because we're overdue for some better standards, and we're starting to see that played out in our trial court. In this case, yes, strict scrutiny should be applied. The court should recognize that this is a non-injury case and that strict scrutiny should be applied, especially in non-injury cases where there's no anchor or benchmark to support the mental anguish award. Looking at whether or not there's any kind of clinical evidence to support it. Here there was not, and it was a very short duration. I see that my time is up. But
I can't give you more time, but I'm asking for a number.
I would say that based on the cases that I reviewed and that we listed in our brief, $50,000 would probably be the upper end of what you could legitimately uphold. That was those cases that we cited, though, are even worse cases than this one. But I couldn't find anything that would be comparable that would be more than about $50,000.
All right, thank you, Mr. Latta. Mr. Daly?
Good morning again. The first issue that I'd like to address is Justice Parker asked about if there was anything in the record about the trial court adopting the special master's findings, and at page 301 of the record, he did not. As a matter of fact, the court concluded that any findings of fact or evidentiary issues would not be adopted by the court. And in the appellant's brief and before you, they like to call this a discovery dispute. Okay, we've heard that a lot. And the reason why is they know they have a problem if it's a sanction. On December 13th of 2019, the trial court entered an order compelling the defendant to respond to interrogatories and requests for production. On December 30th of 2019, the defendants responded, but they did not have an attestation or verification page. Then on April 29th of 2020, the attestation signature page was given. From that point to the time they changed their interrogatory answers was over 1,270 days. That's not seasonably amending your interrogatory response. And it is not a discovery dispute, and it's nice when the parties can agree to something. And in their brief at page 36, they talk about it being a sanction. What they said is they did not want to appeal the portion of the sanction award awarding us fees and costs. But this part on interrogatory number 14, they're appealing. It's a sanction. And the court had two reasons to do this. Reason number one, which is the most common, is Rule 37, which you're all familiar with. I don't need to go into that, for failing to provide answers to that interrogatory as required by his order. The other is the inherent power of the court. And I wrote this down because the marshal said this at the beginning. He comes in and he says, turn your cell phones off because we want to maintain the integrity of the court. That's the other avenue. Courts have inherent power to enforce people to comply with their lawful mandates to protect the integrity of the justice system, okay? And to make sure that this kind of business doesn't go on. In addition to that, in response to, we were talking about interrogatory 14 in connection with it coming in at page 295, the court asked, are you okay with this coming in? And they agreed to it. But here is the crucial issue. Is interrogatory 14 the determining factor, right, in this case? Because there's plenty of other reasons to go off on why it wasn't. We don't know what the jury held, but I think we do as far as the liability portion for sure. We know that when I got up there and closed and told them, hey, this case boils down to this. Who forged that return to work slip? Was it Jada Creagh, as they contend, or was it Bridget Atkinson, the station manager? The defendants came up and used the exact phrase, this case boils down to who forged that return to work slip. We agree. We agree. Who forged that? Because if it's Jada, we lose. If it's Miss Atkinson, we win. And that is what happened in the case, okay? That was the main issue. The other things are window dressing compared to that, based upon that representation. The other issue to move on to was he says it was a drafting error, and that I wrote down. Well, they sued Mr. Fox for intentional fraud, not negligence, not wantonness, intentional fraud, 3 days before Envoy told Judge York what fine character he had. So it's not a drafting error to them. Maybe they come in and say it's a drafting error here, but that's in the record as well.
So is the issue then, if it's a drafting error, the standard's a little bit lower if it was done intentionally, because lawyers are agents, right? They're not principals, so they're representing. If they misrepresent, who's responsible for the misrepresentation? The lawyer. And at what point does the client bear the burden of that misrepresentation, absent some specific direction or knowledge?
Right. The U.S. Supreme Court in 2 cases have held that bad acts on behalf of the attorney, or someone acting on the attorney's behalf, or someone else, we don't even know who did it, is attributable to the client. One of them is Wabash Railway case, and I believe the other one was the National Hockey League case.
So does the imposition of sanction then cure that issue, or the sanction continues, not only that you've sanctioned the lawyers and the clients, but that sanction continues until letting things continue to go forward, and that there's a material misstatement that gets in front of the jury in some argument about forgery?
And that's why the court in its sanction order said, admit the first answer, then Envoy has the ability to come in and say, we corrected it, it was mistaken, and this is our real answer. That's why the court did it that way. The court did not want to try a case within a case. That case is pending elsewhere, and that's what he really, really, really was focused on.
So it's your position the admission of interrogatory answer 14 was a sanction?
Correct. Yes, sir. And they acknowledged it in their brief as well at page 36.
Ultimately, the signature page did not come into evidence.
No, it did not.
And so we're left with an unsigned interrogatory answer as evidence of pretext.
Yes, sir.
Is that sufficient evidence of pretext? Let's assume I don't believe your other reasons for pretext. Is that enough, an unsigned interrogatory answer?
As a sanction, it would be, if you're asking it to the exclusion.
I'm asking, is it
Yes.
sufficient to support the jury's finding a pretext, an unsigned interrogatory answer?
If they made that choice, yes.
Okay.
And then the other thing that Mr. Latta talked about that they didn't amend the interrogatory, I've already talked about that. And there was no offer of proof. I forget which justice asked that.
I did.
Concerning that. But then turning to the issue of the decision maker in this case, it is undisputed that in response to discovery, they said the person that made the decision was Bridget Atkinson, station manager, no one else. They brought several HR personnel, including the head of HR, and they said, we do not make hiring and firing decisions.
Where did they say that Atkinson made the decision?
They said that who was the decision maker? They said that it was the individual, Mr. Wilson.
Right. So
And
they
we say
they
it
did
was
not say
Bridget Atkinson.
that the line supervisor made the. No one has said that, right?
No, we say Bridget did it. They say,
Right, but there's no direct evidence. I know you're arguing that there should be an inference drawn
No.
that the line supervisor did it, but there's no direct evidence.
there's a ton of direct evidence.
I mean, there's no. They didn't give you an interrogatory answer saying the line supervisor did it. The line supervisor didn't testify about that. Nobody else testified. Is that correct?
That's what they say, but that's not true because
Okay,
we have a
tell me the direct evidence
Okay.
that the line supervisor made the decision.
Okay. Well, first of all, the letter that the line supervisor, she signed it, it terminated her, made no reference to HR, made no reference to anyone else other than her doing it. In addition to that, she said, and I want to get this specific, she was shown that letter, and in that letter it says the decision to terminate Creagh was HR's. That was Mr. O'Hara's question. She testified, no, sir, that was actually mine. Furthermore, if it
The line
was,
so the line supervisor Atkinson testified in deposition
right,
that she made the decision.
yes. And she also testified that even Atkinson testified she only needed HR's authorization to fire, not that HR made the decision for her to fire.
Okay, where was? Can you give me the citation for her admission that she made the decision?
It would be in, I don't have the page number.
Okay, but it's in your brief.
It is.
Okay.
And it was, and her deposition was played by video. She didn't come to trial. So that would be in that. Hernandez was the head of HR. He says they do not make hiring and firing decisions for Atkinson. They do not even give advice as to go ahead and fire her. That's not in their lane. Their job description for HR says that they're business partners and consultants, and they make recommendations. Okay. The other issue is they make no dispute that Atkinson has the authority to fire people under her. No doubt about it. That's undisputed. And it was Bridget Atkinson was the only person that, wrote the suspension letter, wrote the termination letter. She was the only one that interviewed Miss Creagh in this case. HR never laid eyes on Jada Creagh, never spoke to Jada Creagh. Everything was Bridget Atkinson.
There is a contemporaneous email from HR stating that she should be fired, right?
Mr. Wilson said that, I believe.
But no, there's a document
Yeah, I think it's an email. if
at the
I'm not
time.
mistaken, from Mr. Wilson. And so in the end, what does the jury do? The jury takes all the evidence we have, takes all the evidence they have, weigh the evidence, and make the decision. And if they found out that Miss Atkinson was not the decision maker, we lose. If they find she was, we win. And that's how this went, and that's how this issue went.
So I want to ask about what the trial judge did during closing, because he had said there was going to be no testimony, no argument about the false swearing on the interrogatory.
Yes.
And when you were in closing, you talked about the false swearing and you had a blow up of it, and you said, look, they've sworn falsely, and they objected and moved for a mistrial, right?
Yes, sir. And this is how that went. The chronology of events were in closing, they got up, they were the ones to first bring it up and said, is this true, Miss Burrell, or not true? That was a testimony. They brought it up, and then in close, the trial court sidebar said, that made me cringe when Envoy said that. Then Mr. O'Hara said, well, Judge, can we say, number one, was it under oath because of that, and that it was not true? He said, yes. Then I come up and I say, not true, and then the standard jury charge about a witness not testifying, testifying falsely to a material fact, you can consider that in your evaluation. Then the judge objected, sidebar. This is where it's critical. They come in, and the judge let Envoy draft the curative instruction themselves. He looked at it, showed it to Envoy, and said, is this okay? And Envoy said, yes, it is. So
You're talking about the curative instruction he read to the jury.
Yes, yes, but before he gave it to the jury.
So it wasn't a jury instruction, it was a curative instruction. Yeah.
Yes, sir. And so that's how that went down in this. And again, that is more evidence that this gets back to why did this case get decided the way it did? So who forged that return to work slip? That's what it boiled down to. And so that's how the curative instruction went out.
Let me ask you the question I asked them. Our law has said that if there's mental anguish, damage is awarded, and that there's no physical injury, that we scrutinize those damages more highly. Is that right?
Absolutely. Strict scrutiny applies.
And looking at our case law, you have the auto zone case, which I think was someone got arrested, and there's another case where someone had their wife leave them, and we reduced the damages in those cases. And those damages were lower than the number here. So if we were to remit the damages here on the emotional harm, what number do you think we should remit them to?
You shouldn't remit them. And the reason why is Rice versus Merchants Food Service out of this court involving the same attorneys, where the court, even though Mr. Rice had lost wages as well, that the court said $350,000, because this is a retaliatory discharge case. This is unlike other types of mental anguish cases. This is your livelihood, right? These are very tough cases for people. And the court said $350,000 would be justified if it was mental anguish alone. That's a retaliatory discharge case. Out of this court, published, same attorneys.
But that was a general verdict that included more than just emotional harm, right?
Right. The compensatory included mental anguish and lost wages, but the court did say that with respect to the mental anguish, the $350,000 award would be good for that as well. And then in Rice, another issue, he wasn't labeled a criminal. He wasn't called a forger. And the Envoy in this case makes the point, it was a short duration, it was long. And I specifically remember this question. As you sit here today, what still bothers you? I asked that question of Jada on the stand. Years after this happened, she says, I'm paranoid. I've been labeled a forger. I've never been a criminal, and I don't trust people anymore. That's more than a few days, which they state in their brief. That was at trial as far as duration.
Just so the record's clear, though, the entire compensatory damages here are emotional harm.
Yes, sir. Yes, sir. And then the other thing on mental anguish, which justifies it, because they really don't want to talk about the facts of the mental anguish, but when she comes in there and Atkinson says to Creagh, how did you enjoy your vacation when she was fired? This, despite the fact that she was suspended, okay, that causes mental anguish damages. She said she felt like she wasn't even in reality. She said that she was so depressed that luckily for her father's a preacher and gave her scripture to read. She wouldn't go out of the house. She didn't even do anything in the house. And that was at the beginning. So a lot of those other issues of mental anguish are here.
I may have missed it, but excuse me over here. Sorry.
Yes, sir. No, that's my fault.
Were there any medical treatment, any kind of treatment for mental health after this, or was it strictly her describing what she felt, or was any medical treatment at all?
No medical treatment at all.
Counseling, anything like that?
No, sir. No,
Okay.
sir.
Okay.
And I'm glad you asked that because a lot of cases, there's a lot of them that don't have that, and Rice didn't have it either. He didn't have any psychological treatment or anything like that. The other thing, which is critical, I got my light on. She goes out, picks herself up, goes to apply for a job. Not only does she have to fill out on the job applications what happened to her in this case, but she had 3 managers to interview her for these jobs. And guess what they were focused on? What happened at Envoy Air? Why were you fired? Tell us all about it. Embarrassed, belittled, stigmatized. Especially, we're talking about a 28-year-old, single female, being put in that position. That's pretty tough. And it's not like she was, and that's another reason why we're not making lost wages, because there was a time where she couldn't even though she was applying and stuff, she couldn't even, pick herself up to get it, but she did. Now, as far as Rice and the amounts, Justice Cook, you asked about the amounts. The great cases are called Moorpack. I cited it in our brief.
Mr. Daly, your time's up. You can just finish your sentence, though, if you want to.
They all talked about the trial court and the appellate court and/or both and/or just one of the courts, and they said they would not mess with any of the verdicts because they do not shock the conscience. Thank you.
Thank you, Mr. Daly. Mr. Latta?
Thank you, Your Honor. To follow up a few questions that my colleague addressed there, on whether or not the line agent, Bridget Atkinson, claimed credit for the firing. Record page 757, where he quotes her saying, "That was actually mine." If you'll look at the line of questioning, both the page before, you'll see that the questioning was about who signed this letter, who signed that letter, did you sign that letter? And then they came to this particular point and she says, "That's mine." She's talking about her signature on the termination letter, and she did sign it. She was, no question, the messenger, but she was not the decision maker. So I think it would be inaccurate to try to cite that record as evidence that she was trying to claim credit for the termination. On the special master adopting the findings, he read you part of the transcript during the trial where the judge at that point had not adopted the findings, but he did enter a written order adopting the findings after the trial was over. It's a picture of a judge who really went back and forth and struggled with what to do with this interrogatory answer problem. But at the end of the day, he did adopt the findings, but not the analysis, again, because the analysis impinges, maybe has some implications for the separate action against the lawyer. So he did not adopt that as the findings of the court. On whether a lawyer's misstatements can be imputed to the client, There's a case that I read recently involving another matter, and it was Adams versus Tractor Equipment Company. I think it was one of Justice Bryan's cases where there had been an affidavit where a lawyer had made a statement that turned out to be factually incorrect. And the court did deal there with whether or not those can be imputed to the client and held that they cannot. And I would like to stress that that should be the rule, that they are not imputable, especially in a situation where they can be amended and corrected, and there's a procedure. That's the reason that we have that process, so that interrogatory answers to complaints, other pleadings of various kinds can be corrected until the pleadings are closed or until the evidence is over. And at that point in time, then it becomes what it is. But otherwise, we get like I said earlier, a gotcha kind of situation where you said something wrong. And even though your client didn't say it and we can't tie it to your client, you said it, and therefore that's your client's position, and therefore you have to be held not only responsible, but in this case, punished for it with a substantial punitive damage award in addition to the...
Mr. Latta, does it matter that it took them such a long time to amend the incorrect interrogatory? Do we factor that in at all, that they didn't do it immediately, or is it a question of when did they know or when did they discover it? Or that seems like, significant amount of time before they amended it here.
Yes and no, Your Honor. Let me just say, in defense of that lawyer, when he saw it, he then, in the next round of responses to requests for production, provided an answer that indicated there was no basis for that claim that there had been a voluntary resignation. But he didn't go back and correct that original answer. You're right about that. He thought it was enough, and he testified to that effect. And all of this is in Mr. Upchurch's findings. Really very interesting to see how that came about. But yes, it wasn't until the defense attorney, Mr. Fox, was replaced and by new counsel came in and then filed a formal amended response to that. You're right. So depending on how you look at it, either was it very long or it was a little long. But they did amend it, and they did amend it properly under our rules. Now, there was a question earlier about whether the admission of interrogatory 14 was a sanction in itself. No, it was not. If you look at the court's ruling, the sanction was a substantial monetary fine in order to cover the expenses of that whole process. And it was over $100,000. It was a lot.
Was it enough when you objected and asked for a mistrial that the judge gave a curative instruction? And is opposing counsel correct that y'all drafted that curative instruction?
Yes, on the drafting, but no, it's not sufficient to cure the prejudicial error. The old saying that you can't unring the bell, because at that point the well was poisoned. Thank you, Your Honor.
Mr. Latta. All right, we'll take this case under submission. Thank you all very much for your arguments this morning.
All rise. The court is adjourned.